Hi drivers, my name is Paul Taylor. I'm the founding attorney of the law firm Truckers Justice Center. We are employment lawyers for truck drivers. So basically the people that we represent are owner-operators, truck drivers, and some other industry, trucking industry employees. So a big chunk of the cases we do are under a law called the STAA, or Surface Transportation Assistance Act. That's the law, the main provision of which President Reagan signed, gave us 80,000 pound gross vehicle weights for tractor trailer sets typically on the interstate network and on what's broadly referred to as the national network. Now, the employee protection provisions of the STAA protect drivers by prohibiting retaliation by an employer, which can include also a trucking company with a leased owner-operator. They are employees, owner-operators, when personally driving the truck, at least for purposes of the STAA's employment protection provisions. So a protected activity under that law is filing a complaint with the employer or the government about a violation of commercial vehicle safety regulations, which means essentially you don't have to prove that the complaint is valid, just that it's based on a reasonable belief of an actual or potential violation. And another provision of the STA protects a driver from retaliation for refusing to operate a commercial vehicle because the operation of that vehicle will actually violate a commercial vehicle safety regulation. So a good faith belief is not enough that there's a violation. You have to be able to, in order to prevail, show that but for your refusal to drive, you would have violated commercial vehicle safety regulations. And of course, we already talked about complaints, but on refusing to drive, that's essentially under one part of the refusal to drive protection. You have to show there would have been an actual violation. Now, I get lots of drivers who call me who say I got fired because I refused to drive with a missing IFTA sticker, or I refused to drive with a missing license plate. That is not protected under the STAA. You have to be refusing to drive because driving would violate a commercial vehicle safety regulation. Now, am I going to tell you to drive without with a missing IFTA sticker or things of that nature? No, but that kind of refusal is not protected under the STAA. It may be protected under a state law. It might be protected under some other statute, but for the STAA's refusal to drive provision to apply, in fact, to protect you, you have to show that but for your refusal to drive, there would have been a violation of a commercial vehicle safety regulation, which can include overweight because that's related to commercial vehicle safety. The other protection under the refusal to drive clause of the STAA is a provision that says you are protected when you refuse to drive based upon a reasonable apprehension of serious injury because of the vehicle's unsafe condition. Now, that's not going to apply to a missing IFTA sticker. It's not going to apply to a missing license plate. Again, you may be protected under another law, but the STAA protects two types of driving refusals. One, where driving will actually violate a commercial vehicle safety regulation, state or federal, or two, where the refusal to drive is based on a reasonable apprehension of serious injury because of the vehicle's unsafe condition. If you have any questions, give us a call.